Brian, can you also talk about these aggregation rules and kind of going to Doug's point, like what are you looking for from Treasury in ways that would, try and respect and reflect the existing arrangements that are out there,
Sure.
without necessarily encouraging companies to do, people call it the cracking back, to sort of disaggregate and re-aggregate themselves?
No, yeah, I thought Doug raised some very good points. I think from our perspective, sort of a broad aggregation rule would address his concerns. So think about it this way. So my favorite manufacturer out there in Ohio, he employs 300 people. He's got 5 different entities. He has the common paymaster structure that Bob talked about, where all his employees work for one LLC. Right? They're all over here. But there's no revenue going to that LLC. All the revenue is in the other 4 entities that he has. And he has those entities because they're in different locations, because they operate different things, because maybe he's got some different investors. But he's got these 4 or 5 different entities. All of their wages are in one. So if you apply a strict, you're going to have to calculate this 20% deduction per entity, he's not going to get the deduction at all, because all his wages are in an entity without any revenues, and all his revenues are in entities without any wages. So the wage limitation on the 20% deduction is going to give him a big fat zero. So the question is, okay, does Dan have to reorganize in order to get the 20%? It's going to raise his operating costs because he's no longer going to have just one payroll operation and one line of credit and all the different things that he works through the LLC. Or is Treasury going to recognize that this situation is extremely common and that he should be able to aggregate the rules? They have existing rules. They're under 469 of the code. They've already dealt with this through the statutes and regs and legal cases. So they already have a broad means of determining who could be able to aggregate and who can't. And to Doug's point, though, the beauty of it is not only does it make sure that Dan gets the deduction that he should as a manufacturer out there creating lots of jobs, but it also gives Treasury the rules so that they can go after the crack and pack. Because the challenge with the 20% deduction is not people gathering together businesses to get more of a deduction. I don't know of a scenario where that would work. Where it's going to happen is where they try to break up a law firm or other specified services businesses in order to get like activities that might qualify and get a deduction for those. Well, the aggregation rule gives Treasury the ability to look at that and say, that's not an appropriate disaggregation of your business. We're going to aggregate this. This is a law firm. Who are you kidding, right? It's a law firm. You're going to get treated like a law firm. You don't get the deduction. So it really gives Treasury the rules to go after the bad actors, and it makes sure the businesses that are legitimately organized with lots of entities get the deduction that they deserve.